The North Gauteng High Court in Pretoria has ruled that the recording of accused number 2 Bongani Ntanzi's alleged confession without his consent violated his constitutional rights. As a result, the presiding judge has found that the audio should not be admitted as evidence. State witness Magistrate Vivian Cronje earlier testified that she did not inform Ntanzi that she was recording the session. Ntanzi and 4 others are charged with the 2016 murder of soccer star Senzo Meyiwa. SABC News' reporter Griselda Lewis, of course, has been on top of this very complicated court case for us from the beginning. Griselda, sure, and a very interesting court ruling that changes the course of this trial, surely.
Well, absolutely, Francis. In a precedent-setting ruling this morning, Judge Rata Mokgotleng found that there was a basic flagrant flouting of accused number 2 Bongani Ntanzi's rights. Mokgotleng ruled that allowing that alleged audio recording to be part of the proceedings would bring the administration of justice into disrepute. Let's watch what he said while delivering that judgment.
This court is enjoined to declare evidence which was acquired unconstitutionally to be inadmissible, as I'm doing about the very recorder of the Section 217 interview from its beginning to its end. Because if this court allowed such an egregious flouting and flagrant flouting of accused number 2's constitutional rights in terms of Section 35(5), it would not be in the interest of justice to do so, because accused number 2 would then be continuously subjected to a trial unfairly, when we know that the Constitution engages us and enjoins us to prevent such an exigency. And also, in the view of this court, that would bring the administration of justice into disrepute. Consequently, this court rules that the audio recording should not form part of these proceedings. It is inadmissible.
Now, you'd recall, Francis, that Magistrate Vivian Cronje's cross-examination had been delayed after, of course, we saw the defense wanting to take a listen to that audio that has now been declared inadmissible. It will not be used as part of the state's body of evidence. And essentially, that delay meant, of course, that there had to be a ruling after those, or that 3-hour clip, if I may, had been listened to by the defense as well as the accused. With today's ruling, we could go ahead now and continue with the cross-examination of Cronje. So straight after that ruling, cross-examination of Cronje commenced. Cronje, you would recall, previously testified that accused number 2, Bongani Ntanzi, had willingly, not under any duress and in the presence of his lawyer, Dominic Mjiako, made that alleged confession. But today, Ntanzi says he does not even know whom Mjiako is.
Other than a confirmation by the interpreter, there's nothing that you can confirm that Mr. Mjiako was present on that particular day.
Your client can confirm that?
It's my instruction that he was not represented on that day, and he does not even know Mr. Mjiako. It's my instruction. That's why I'm still insisting on the right to legal representation.
If that is your instruction, then your client is not telling you the truth.
Well, Ntanzi, through his lawyer, says he didn't even pen any signature or any document, including the so-called confession in front of Cronje, who says she took down the statement or that confession, Francis. Let's take a listen to what was said there.
My instruction is that he has never or did not attach any initials, and he did not sign any statement, especially in front of you.
That is a lie.
Sorry, I'm not interfering with your interpretation. Say, sir, that is an familian.
That's correct.
Can you just say it in English?
It's an absolute lie.
It's a notorious lie.
Yes.
You said he signed on page 8.
That is correct.
Page 8 is a pro forma.
That is correct.
It's not a statement.
That is correct.
All right, Francis, you recall that at the center of this trial within a trial that is now sitting was the issue relating to accused number 1 and 2, saying that they were beaten up or tortured into a confession, while the defense continues to contend that Ntanzi was tortured. Cronje says he never told her that on the day that she allegedly took this confession.
My instruction before you descend on that box is to tell you that he was subjected to a severe assault, severe torture in 4 different places before he was brought to you to make such a confession.
I advocate that this gentleman made it known to me on several occasions, in several ways, that he was not assaulted. No injuries were shown or pointed out to me or were visible to me. Even when I had asked him about those or such injuries, he referred me or mentioned to me old wounds or injuries that occurred or was as a result of an incident between himself and his grandmother when he was still very young. There was no reason that he preferred to me, or that he should not have pointed or shown me or told me about those injuries or injuries that he had at the stage or that were caused by police on him.
All right, so Francis, cross-examination is going to continue on Monday. We're expecting the other defense lawyers to be quite brief, as of course this is the issue relating to the cross-examination or the testimony that was given by Cronje does not relate to their clients, but of course to accused number 1 and, I beg your pardon, accused 2 in this instance. But there was also some reaction from the lawyers representing Ntanzi on the court ruling or the judgment by the presiding judge this morning. Let's take a listen to what they had to say in response to what some would term was some sort of victory.
We are so delighted to receive the outcome of the finding of the judge in relation to the evidence of the tape recordings, in that the court found that it was unlawfully obtained, so that cannot be used in these proceedings in future.
All right, thank you for a comprehensive report. As always, Griselda Lewis.